Hello everyone and welcome back. In this video I'm going to talk to you about the Marchman Act and specifically a very important and critical change that was made to the Marchman Act in 2024. So as you probably know by now, having done a bunch of research on Marchman Act, there's two steps to this. The first step is the assessment period, and the second step in the process is the treatment services. Now in 2024, before the changes, it required two filings, a petition for assessment and then a second petition for treatment services. Now it's one filing. So if you don't ask for it, you don't get it. It's waived and you cannot get it back. You'd have to start a whole brand new case again. Now, the assessment period, which is key and critical to the whole case, because without an assessment, you're not getting anybody into treatment. In the old statute, it provided for a request for an ex parte order for assessment and stabilization. And that order, in addition to ordering the assessment, would also order law enforcement to go and get the person. Now, the one thing the statute did not say was that an ex parte was an emergency form of relief. Now, we would title our document emergency petition, for assessment and stabilization, filed on an ex parte basis. But the statute never said emergency, which meant that for the most part, most of the time, when we would make that request for emergency relief, it would get granted, and the police would go out and pick the person up, or our investigator would go pick the person up. But either way, there would be this granting of emergency relief, which was a really powerful tool for us. In 2024, they made a bunch of changes to the Marchman Act statute, one of which was the statute specifically now says that if you want an emergency ex parte order, you actually have to establish that there's an emergency. Okay, and it actually now includes the word emergency. Now, it does not define what an emergency is, but that is going to be up to the interpretation of the courts. And I can tell you from what we are seeing, there are some counties that are being far more conservative in their granting of these requests for emergency relief. We're seeing a number of counties that are saying, sorry, you didn't really establish an emergency. Somebody is not at risk of dying, right? There's no life or death situation here. Specifically, if they are already in treatment, a lot of judges are saying, sorry, it's not an emergency. He's in treatment. I get it. He or she may be a flight risk. I get it. He or she has a history of going and then leaving. They are med not compliant. They don't go to groups. They don't do the therapy. I get it. But right now they are in a position where they are safe, and it's not an emergency. Now, if they leave, well, come back and tell us they've left. Now we might consider it an emergency, but this is an important thing to know. And as I've said in other videos, it's not just about knowing your judge, it's about knowing which county you're in. And as I've said, some counties do this better than others. Some counties, I won't even file the case. I won't take your money. You're going to waste your time, your energy, and your money filing in these counties. And I'm not going to get into why it's a waste of resources, but it simply is, and I won't file the case there because you won't get the result that you want. In fact, it'll just be more frustration for you and for my team trying to get you the result. But this is an important change, okay, to the statute. And if it's not an emergency, what the court's going to do is it's going to set the petition for assessment, the request for an assessment, for a hearing. And that means now in the Marchman Act, in some counties, instead of one hearing, we're going to be having two. And that's just the way it is. I'm not thrilled about it. There are some other changes that I am not thrilled about. But listen, the legislature saw fit to change the statute, and we have to operate within the four corners of what the statute says. And some judges are going to interpret it one way, and other judges are going to interpret it another way. And that is, in some ways, the beauty of our system, right? So I wanted to share that with you. And if you want to learn more about the Marchman Act, check out our website. You can call us, talk to Brittany or Rachel in our intake department. They will be happy to chat with you and see what options may or may not be available to you. Perhaps the Marchman Act is not the best option based on where you live, based on the facts of the case. All of those things that are important to consider. But if you're going to work with a lawyer who's only handled a few of these cases, they're just simply not going to know that. And that's not a poo-poo on them. I'm sure they're probably a good lawyer, but we've handled hundreds of these things all over the state. And I know which counties do it right. I know which counties do it wrong. So with that said, I appreciate you tuning in. I'd love a thumbs up, and please subscribe to the channel. Take care. See you in the next video. Bye-bye.